In today's episode, a little defamation spat between barristers. So what's all this about? Well, it's all about a tweet, and I'm going to read it out to you. A barrister, and the barrister is named, led a campaign of harassment of a trans woman so wicked that she sought to take her own, and you know the algorithm, sort of self-delete, unalive, whatever you want to say. Continues, J.K. Rowling saw this barrister could be punished for that conduct which jeopardised life and offered to pay her legal costs. That's where Rowling is now. And I'll put a little screenshot of the tweet up, because you may notice somebody commented underneath raising a case called Mitchell and Jobs, which I have spoken about before, but there does seem to be some interesting parallels. So what's the issue here? Well, as you can see then, it's all about sort of rowing about trans rights and gender critical beliefs, which of course are protected beliefs. See my previous videos on what a protected belief is. I've done 2 of those, did them up while I was up in Bristol. And it is fair to say a sort of a complicated and quite counterintuitive test. But the fact of the matter is that you are allowed to hold gender critical views, which means you are allowed to hold them, you are allowed to express them, and you are allowed to manifest them, but they can be limits. Same with any protected belief. Nobody can stop you believing anything you want. Generally speaking, you are allowed to profess those beliefs and say, this is what I believe in. But then in acting on those beliefs, there might be limitations. So I've got my sort of, rights to religious belief, but Article 17 of the ECHR says you can't use a convention right to undermine somebody else's convention right. So I can't bring back human sacrifice because that would interfere with somebody's Article 2 rights. But in this particular case, the barrister in question, the one who has allegedly been defamed, she has said that she is now issuing proceedings. And she's got all J.K. Rowling's money behind her, so I don't think this one's going to settle. But, what are the chances here? So I'll look at the issues. I don't want to get too much into the detail. But I can talk about some of the sort of wider issues. I mean, first of all, is the statement defamatory? Well, as I've said before, this would all go to what we call a meanings hearing. The judge would say, right, I don't care what you say it means, claimant. I don't say what you say it means, defendant. What would your average hypothetical reader of that tweet, not too naive, but also not too prone to scandal and gossip, and who wouldn't analyse this like a lawyer, in other words, overanalyse it to death. They'd just look and say, right, what do I think that means? And I think there's certainly an argument that the implication there is that the barrister in question engaged in behaviour that amounted to harassment, and it was so bad that it caused somebody to try to unalive themselves. Is that defamatory? Well, yeah, it certainly seemed to be, because obviously you heard somebody had done that, you may well think less of them. It might lower their reputation or cause right-minded people to shun and avoid them. So on the face of it, the statement is quite clearly defamatory. Are there any defences though? I suppose the obvious defence is somebody could say, it is true. Now, what would you have to show to establish it's true? Because this all goes back to the Mitchell and Jobs case. That was the one in Australia where it was the row between the person who exposes cheating in video games, who was in an ongoing spat with somebody who they said was cheating, but they also said that person had gone after somebody else who'd called him out for cheating to the extent that that other person had unalived themselves. And the court in that case said, well, you would have to prove that there was behaviour that was causative of somebody doing that. And the problem for Carl Jobst was that the guy's own family had said it was nothing to do with that. He was just suffering, he had lots of issues on in his life generally, and it's all very sad, but he just couldn't cope anymore. But the family explicitly disclaimed that Billy Mitchell's conduct had anything to do. So Carl lost that case. But it'd be a very similar thing. I mean, obviously all cases turn on their own facts, but I think it would be a very similar test. If you were to plead truth, you would have to say, yes, what this person did was causative, or at least contributed to the actions that the other person took. Now, the one good thing here is, for the potential defendant, is that the person is still alive. So they can come along and say, yes, I did this as a result of that behaviour. So that's, that makes life a bit easier. although apparently there are also tweets there where this person, this trans woman, and I'm going to use people's preferred pronouns and stuff now, you know, without starting a row in the comments. Apart from anything else, I just think it's polite. You just address people as they wish to be addressed. You know, because I operate in a sphere where we have to call people, you know, your lordship and your ladyship. I mean, you know, I get to be called learned, and I'm like, you know, freaking idiot, aren't I? So I'm not going to sort of get into that. But yeah, in this particular case, she's also tweeted and said, actually, I was driven to do this by the behaviour of the Green Party. So that might undermine any potential defence there. What about the other defences? What about opinion? Can you say this is an opinion? Not really, it's more a statement of fact, isn't it? Because you're explicitly saying, as a result of these actions, this happened. It's not something like, in my opinion, this behaviour was so bad that it is worthy of condemnation or unbecoming to somebody or anything like that. Or even, in my opinion, this is the sort of behaviour that could drive somebody to do this. So I think opinion might be a bit of a difficult one. What about the public interest defence? Well, like I said, there's a two-part test there. People always get this confused. You've got to show, first of all, that the discussion is in the public interest to have. And, you know, this sort of thing, arguably, yeah, it's very much in the public interest to sort of have these debates. I mean, should members of the bar be saying this? It's all about, you know, freedom of expression, Article 10 rights. You know, it's clearly an issue in the public interest. But the second limb that most people forget is it in the public interest to make the statement you did at the time and in the manner you did? And the problem here is we don't have the Reynolds defence anymore. That's been officially abolished. And it's not supposed to sneak back in as a checklist, although it clearly has snuck back in as a checklist. But that's all things like give the person a chance to respond. You know, give them a right of response. Go to them and say, well, what do you say about this? I'm going to say this, what do you say? And then report anything they come back with. I mean, it's perfectly fine to say we reached out for comment and they never responded. But if they do respond, you'd have to say something like, they've denied this and they've said no, and they've said this and they said it's something else. So again, I think that might be a sort of, you know, tricky hurdle there. But we'll have to wait and see. I mean, there's all sorts of issues here because the barrister who did the tweet against the other barrister has also drafted a complaint to the Bar Standards Board about this. So although this wouldn't strictly be relevant to the issues the court has to decide, it opens some very interesting cross-examination questions about, well, hang on a second, you know, you insist on your own Article 10 rights, but you're always trying to oppress other people's and all this sort of thing. So, you know, it's going to be a quite interesting one there. But I will follow this and I'll keep an eye on it. I mean, like I say, it's early stages yet. I mean, the first thing, somebody would have to send a letter before action saying, you know, I find this is defamatory. I give you an opportunity to delete this and apologise and maybe pay me some money. I've spoken before about the old offer of amends procedure. That's where you sort of go, actually, yeah, I really have screwed up here. I really wish I hadn't said that. So you can say, okay, I'll do an offer of amends. I will retract the statement. I will apologise. You know, ideally in a format that the potential claimant agrees with. In the olden days, that capped the damages at £10,000. I mean, it doesn't now, but it does significantly reduce damages, and it also makes sure, you know, you're not looking at aggravated damages or anything like that for sort of repeating the allegation. So we'll have to see. You know, we'll have to see what happens there, and if there is any sort of background offers. I mean, it's always the courts do encourage us to sort of settle these things, and all for ADR, alternative dispute resolution, mediation, and all that sort of thing. But a lot of the time, especially on Twitter, I mean, the courts do tend to treat Twitter a bit more like slander. Because it's impermanent. And we also, you know, libel's written, slander's spoken, but that's not quite true. It's more libel has an element of permanence about it, and slander is more transient. And now we've got the serious harm test in defamation. It's perhaps the distinction is less relevant, because in the old days, libel was actionable per se. You didn't actually have to show any damage, whereas for slander you actually had to show it caused you damage. Now for any sort of defamation you have to show it causes you serious harm. So that's another hurdle that the claimant has to get over. They'd have to say, as a result of this has caused me serious harm. But of course it's disparaging somebody in their trade, profession or calling. It's effectively saying this is unfit behaviour for a barrister to engage in. And also if people, you know, have been tweeting and all sort of rows on Twitter and more harassment backwards and forwards and all this sort of thing, it's probably a relatively easy thing to stick in there. I mean, it's an interesting one about the Article 10 rights, because the Bar Standards Board, they've issued their social media guidance, and it's probably fair to say that while they have clamped down on a few people for the way they've engaged in things, where it's not been public speech, it's just been people having a slanging match and saying untrue allegations against each other, they just step in a case like that. But generally speaking, the mere fact that you express a view, especially a protected belief, even if other people, don't agree with that view, the Bar Standards Board are very much sort of hands off. I mean, they've explicitly recognised now, that sort of gender critical views are fine and acceptable at the bar. So I think I can't see the Bar Standards Board complaint going anywhere either, unless it's so beyond just commenting and it is actually targeting somebody for harassment or anything like that. I mean, that's a separate issue, and I'll keep an eye on that. I mean, my prediction is that one's not going anywhere. But what about this libel case? I do think this one could actually run, especially bearing in mind that the claimant is well funded, because obviously usually it's just the cost implications that put people off defamation. But I just thought you might find that interesting, and like I say, it very much reminds me of the Mitchell and Jobs case in Australia, and it wouldn't surprise me that if this does go to trial, that case gets referenced, because although it's an Australian case and it's only a first instance case, so it's not binding in any sense, sometimes you can argue these cases are persuasive and say, well, look, this issue's already been thrashed out in front of a very experienced defamation judge, and that judge said this is the test that needs to be applied. So it wouldn't surprise me if you see those coming across. But anyway, as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate. I'll keep an eye on this one and I'll keep you informed.